Good evening, everyone. We welcome you all in today's webinar on Decoding Overseas Investment Rules and Regulations 2022. This webinar has been organized by Resurgent India Limited. I am Sandhya Tabar, part of Resurgent Group, a growing investment bank which offers services in the line of mergers and acquisitions, private equity, debt solutions, structured finance, capital market solutions, transaction advisory, valuations, enterprise risk, trainings, and etc. Just to give you a brief about the topic of today's session, the Ministry of Finance, Department of Economic Affairs, and the RBI have recently released the Foreign Exchange Management Overseas Investment Rules 2022 and the Foreign Exchange Management Overseas Investment Regulations 2022. In addition to these two rules and regulations, RBI has also issued Foreign Exchange Management Overseas Investment Directions 2022. RBI has also updated the Master Directions on Liberalized Remittance Scheme, in which they have amended to align it with OI framework. And it has now, so the LRS has now been categorized into two categories. Number one, ODI, which is Overseas Direct Investment, and number two, OPI, which is Overseas Portfolio Investment. The new regime signifies the government's attempt to simplify the regulatory framework relating to overseas investments by person resident in India and to promote ease of doing business. Under the new OI rules and regulations, the pricing guidelines have been more rationalized and simplified. Also, Indian entities not engaged in financial services can now invest in a foreign entity engaged in financial services. Before we start with the session, I would like to invite our speakers for today's session. We welcome Ms. Pallavi Dinodia, partner at SR Dinodia and Company LLP. She's an established expert in taxation. In addition to her chartered accountancy expertise, she's trained as a lawyer and has worked with numerous global and domestic businesses in Europe, Asia, and India over the past 2 decades. Her extensive domain knowledge and solution-based approach have enabled her to successfully lead cross-functional teams, identify initiatives, and deliver results. As a partner at SR Dinodia and Company, her experience has spanned multinationals, large publicly held companies to family-owned and non-profit organizations. She has worked extensively with global businesses across Asia, the US, and Europe on advisory and transactional work. She has also played a strategic role in advising on transactions which utilize her experience in valuation, corporate and tax laws, combined with her understanding of finance and accounting. Additionally, Pallavi has an experience serving as an independent director on the boards and board committees of publicly listed companies and international organizations. This has included serving as the chairperson of APAC region and as a key member of the Global Governing Council of MGI Worldwide, one of the largest global networks of accounting, audit, and taxation firms. Welcome to the webinar, Pallavi, and thank you so much for joining us. Next, we have Sumit Kochar. Sumit is a corporate lawyer and partner at Ahlawat and Associates with a decade of experience in legal and regulatory matters. He specializes in inbound and outbound investments, family office advisory, intergenerational wealth management, private equity investments, corporate restructuring, fund formation and structuring, and mergers and acquisitions. He possesses a robust background of working on corporate transactional and advisory mandates, regulatory approvals, and regulatory representations. He works closely with several most renowned family offices and private equity funds. He represented clients in a number of private equity, capital market, and M&A transactions involving companies from many different industries, including technology, retail, hotel, manufacturing, real estate, and finance. Thank you so much, Sumit, for joining today's session. Thank you.
Thank you.
Next, we have Kalpit Khande, partner at ACOM Legal. Kalpit is a transactional lawyer and has experience of over a decade in advising on a range of corporate, commercial, foreign investment, and securities laws matters. He is a law graduate and an associate member of the Institute of Company Secretaries of India. He regularly advises clients on deal structuring, M&A transactions, inbound and outbound investments, joint ventures, corporate restructuring, investment structuring, strategic alliances, settlement deals, capital market deals, acquisition of stressed assets, and private equity deals. He has worked on a variety of earn-out and deferred considerations transactions. He has experience in negotiating a wide range of transaction documentation, including share subscription agreements, share purchase agreements, shareholders agreements, etc. Kalpit is also an avid speaker at various forums and events organized by ICSI, ICAI, and other professional chambers. Welcome, Kalpit, and thank you so much for joining us.
Thanks.
And lastly, we have Abhik Ghosh, partner at Quilon Partners. Abhik has worked with Quilon Partners since graduating from the National University of Juridical Sciences, Kolkata, and presently leads the New Delhi office of the firm. His practice covers domestic and international M&A, private equity, and other corporate matters. Over the years, Abhik has represented numerous multinational corporations, private equity firms, and other corporate clients. Welcome, Abhik, and thank you so much for joining today's session with us.
Thank you.
So before we start the session, the main body of the session, I request all the participants to please write their questions in the Q&A box, and we will take up all your queries at the end of the session. So my first question is to Kalpit Khandelwal. How are the overseas investment rules and regulations likely to impact Indian entities? Would you like to share your views on this, Kalpit?
Thanks, Sandhya and Resurgent team for inviting me. The new overseas investment framework, which is broadly divided into three, the rules, the regulations, and the directions, is going to impact the Indian corporates to a large extent, and has opened to a large extent the foreign jurisdiction where they can now explore their business and can take the benefits of foreign jurisdiction. Various provisions have now been clarified and new concepts have been allowed, which was earlier prohibited, like the round tripping structure, which was seen as a negatively and was prohibited, now have been expressly allowed under the framework itself, subject to certain conditions, which we will deal with later. Then there are deferred consideration, which have also been allowed on in respect of acquisition of equity capital in a foreign company. Similarly, the disinvestment involving write-off beyond a certain limits have also been allowed. And so there are many new concepts which have been brought in. There are many clarifications, the lacunas which were slightly ambiguous earlier in the erstwhile regime now have been clarified. So it has now created a big impetus for all the corporates, the Indian business houses, to go and compete with the foreign companies. And therefore, now we foresee there will be the deals which have been stopped for or was kept on hold for almost a year since the draft regulations were kept, was introduced last year somewhere in August 2021, pursuant to which some deals were kept on hold. Now we foresee that all those deals will revive, and there will be much more deals which will come into the market.
Okay. Pallavi, would you also like to share your viewpoints on this one?
Sure. Thank you, Sandhya. Thank you, Kalpit. So I'll just add to what Kalpit is saying that, I think the question is how overseas investment rules are likely to impact Indian entities. Personally, I think this is the single largest liberalization measure that any government has taken over the last few decades. Just like India was liberalized and we had huge capital inflows, in the 90s, once our economy was liberalized, our foreign exchange outflows was always seen as a very tight, tightly regulated environment where we were only allowed to do very few things. And as the world converged, and today we say that the world is flat in some sense with digitization, etc. And now with a lot of digital assets coming into the foray, I think this government has liberalized the foreign outward remittance whole gamut completely. So I think it's a complete game changer for Indian entities, whether listed, unlisted, mutual funds. And I know that you will deal with these questions maybe more in detail later. But just as a precursor, I'd like to say that I think this is a complete game changer and a very welcome move. Like Kalpit is saying, a lot of Indian entities who want to invest overseas were not doing that because this was a gray area. Now I think with the new rules, regulations, guidelines, directions, operational instructions, lots of new things that have come in, a lot of clarity has come in, and I think for the better.
Yeah.
I would like to add here, Sandhya, if you allow.
Yes, please.
Like if we see in the directions how these directions are being framed and written in a manner that they are specifically stressing upon the points that they have done away with various aspects like prior approvals with respect to, especially if we talk about investments by person resident in India under investigations by any investigation agency. There is no prior approval required for that.
Right.
So as Pallavi was mentioning, the procedural aspects and operational aspects are yet to be tested. But when I read these, I was also pretty shocked as to how this will play through. And with respect to, say, deferred payments, they have also been allowed without any specific approval earlier, for which approvals, say, I guess 7 to 8 months were required, and various clarifications were required. Even the so-called round tripping structure, which I won't call it round tripping, but say ODI-FDI and Indian subsidiary structure. So these are pretty welcoming moves. As in the government is trying to align with the overseas practices and also making it in line with the Companies Act also, which restricts two layers step down subsidiaries.
Yeah, right.
So let's see how it plays now.
Yes. Thank you so much. I would like to ask to Kalpit, how is the new overseas investment regime likely to affect the much discussed ODI-FDI structure and round tripping? You are on mute, Kalpit. Please unmute yourself.
Sure. See, under the erstwhile regime, there was no clarity per se, except the fact that there was certain compounding order which was issued, and subsequently there an FAQ was issued also by RBI, which sort of prohibited ODI-FDI structure, wherein an Indian entity used to make investment in a foreign company, and that foreign company either at the time of investment itself had investment in an Indian company, or subsequent to the investment by the Indian entity in foreign, they make further investment in an Indian company. That was something not allowed per se, and there was several compounding orders and show cause notices which was received by Indian corporates, wherein RBI has either suggested two options itself, that either you disinvest your investment in a holding in the foreign company, or let the foreign company make disinvestment of its holding in the Indian subsidiary. So this feature, ODI-FDI structure, which has now been allowed subject to certain conditions, which we will deal in later, is going to really impact the Indian corporates by accessing the foreign capital at a much cheaper rates, which are easily available. They will be able to, various private equity players and various big investors who were not very keen to invest in Indian market because of the regulatory restrictions or due to difficulty in enforcing various tag along right, drag along right, which we normally provide in our shareholders agreement. The enforceability challenge, which is not there as compared to in India, in Singapore, in Cayman Island, which are easily enforceable and strongly enforceable. I would say, and therefore the Indian corporates will be now able to access the foreign capital, and even in respect of the transactions or business which they have in India purely. So by using this ODI-FDI structure, after complying with the conditions which have been laid out. Furthermore, there we have noticed that certain jurisdictions, particularly like Singapore, have been seen as a positively from a IP enforcement perspective, intellectual property enforcement. So the many tech companies are, I'm surely going to see many tech companies to see the externalization where they will have a holding company overseas, and one of the company in India, main operating company could be an Indian company, as well as various other operating company in other jurisdictions. So the holding company, I foresee them now going to be more in overseas jurisdiction as compared to the India. So this allowing of ODI-FDI structure is going to really impact the Indian corporates, and new deal structures which will come up. The structuring, I foresee that there will be a big change on that front.
Yes, thank you. Abhi, would you like to share your perspective on this?
Sure. Thanks, Sandhya. And as Kalpit rightly said, I think it's a great development that this sort of a structure is now being expressly recognized, because up until now, for I think far too long, it was sort of this without an express prohibition, but it was just something that when you're structuring a deal, you have to keep in mind that an overseas target with Indian which had existing Indian activities that could create issues. I think now with the new sort of liberalization that's been introduced in the overseas investment rules, certainly I think for Indian corporates looking at overseas investments, it definitely widens the scope of potential targets, because they can now, it's a lot clearer now that even if there's an overseas target that has that has existing operations in India, clearly now this is something that's expressly recognized and blessed by the regulator. So there's no doubts there. I think one possibly one area where we might see some development and hopefully maybe some guidance from the government is just how to look at this, the stipulation on the layers of subsidiaries, because since the clarity has been given in the OI rules that that the foreign entity that has received overseas investment from India can also can have investments in India, but subject to not having more than 2 layers of subsidiaries. Now, the question really is that when they say 2 layers of subsidiaries, should we only be considering subsidiaries in India, or would it also cover, subsidiaries outside of India? Because I think from a Companies Act perspective, it's very clear that you would be able to exclude your foreign subsidiaries. But, just given the way that the rule itself has been framed, where certain exclusions from the Companies Act have been clearly brought in, which refers to certain categories of companies which are exempt from this from the restriction on subsidiary layers. But the other stipulation that's there in the rules under the Companies Act, which basically says that that overseas subsidiaries need not get counted as part of that chain, that is not part of the overseas investment rules. So I think it'll be quite interesting to see how this whether it's an express omission or not, but how this should be looked at. But because currently, at least, I think there is a view that's being taken that perhaps the layers of subsidiaries you should also consider your overseas entities as well. So which to some extent it does restrict your structuring options a bit, because then you have to ensure that when making your overseas investment into, say, a group that has existing India operations, that investment comes in at a level that is not, that's not very high up in the ownership chain. But that, hopefully it's still early days for the new rules. So hopefully we should be getting some clarity on how this particular stipulation should be looked at.
Yes, absolutely. Thank you, Abhik. My next question is to Kalpit. Can you elaborate on the conditions set forth for round-tripping structures?
Yeah. So as Abhik told that they, and I say that the round-tripping or ODI-FDI structure, which we normally call, have now been expressly allowed, but subject to certain condition. And one of the condition is that it should not have more than 2 layers of subsidiary, on which Abhik has clarified and a lot. So I would like to highlight one more aspect, that when the draft regulations came in almost a year back, there was one more additional condition which was stipulated, which had now seen and not been captured in the final fine print, which was in relation to that such ODI-FDI structure should not be a tax evasive or tax avoidance structure. And it's good that RBI has not gone into the domain of taxation authorities. Otherwise, each structure would have been personally would seen or perceived as a structure which was made just to avoid taxes. And the ODI-FDI structure have been done only and only to make benefit of the taxation. So that condition now have been deleted from that, which was there in the draft regulations, and have not seen the light. The another condition is really in relation to the bona fide business activity. This was there under the erstwhile regime as well under the new regime. But what is better and what is good, that now it has been defined also under the law expressly. So the bona fide business activity has been defined as to include that activity or business activity which is permissible or legal under the India as well as in the host jurisdiction. So a business activity which is not legal in India cannot be invested, or no ODI-FDI structure or overseas investment can be made in respect of such business activity as well as. For example, a private individual or an Indian private company cannot make investment in a defense sector subject to certain other exceptions. Similarly, that now no foreign investment can be made in such, or a profit making education in a profit sector education business activity. That is also something which is not allowed in India, and therefore those kind of structure though may be allowed in overseas, but an Indian party or an Indian entity cannot make investment overseas in such a structure. And therefore that bona fide business activity, which was somewhat in past linked with ODI-FDI structure, that it is that why a entity should have a overseas investment and then in turn have an Indian entity, why not directly an Indian person can make investment in the Indian entity, and why to route it, and therefore it's not a bona fide business activity, now have been clarified that it will not be meant or to be interpreted in that manner. It has to be interpreted only in a manner that it is legal permissible activity under India and as well as the host jurisdiction. So the another connected topic with the subsidiary, because when you have to see whether it's a subsidiary or not, you have to see whether there is a control or not in that entity. So control has now also been defined under the overseas investment regime, the new regime, which is slightly different from all other laws in India. There, in almost all laws, there is a concept of 26% or 50%, more than 50% of the voting rights amounting to a control. Whereas under the overseas investment, this regime, it has now been considered to be 10% or more as control. Whereas leaving the entire definition of control as verbatim as of under the Companies Act. Hence, there seems to be some kind of a confusion seems, and I'm sure RBI will come up with some clarification in near future, that how the control to be construed and how can it be seen when there is only a 10% investment in an entity, which is a pure financial investment. How can that be construed to be a control? Or say 11%, because it's a pure passive investment, and seeing it as a control and treating that entity as a subsidiary will be difficult. Having said this, subsidiary and connecting it with the control is also to be seen from a foreign entity perspective, that foreign entity should have 10% or more. If Indian entity making an investment overseas, And to see it from a subsidiary angle, then it is to be applied from the Companies Act perspective. And therefore, now there is a control and subsidiary definition to be seen from differently from an Indian entity perspective and differently from a foreign entity perspective. So here there is also one more lacuna, or I would say not lacuna, or little bit of ambiguity, which I'm sure RBI will come up with clarity and clarify it further. So these were the main 2-3 main conditions, and one of the condition which Abhik has already spoken in more detail about the 2 layers of subsidiary and the ambiguity surrounding it also. So I'm not going into much detail. So these were the main conditions.
Thank you. Sumit, would you like to add something to it?
Yeah, so taking a cue from Avik only, so like he was mentioning about the fact that still it is to be tested as to it will apply on the overseas structures or the Indian structures per se as per the Companies Act. So we were recently advising a family office which like earlier they were facing issues pertaining to seeking prior approval for the step down subsidiary structure in India, wherein in the overseas entity they were shareholders. So what happened is, so there are 2 layers of subsidiaries in overseas entity, and the AD Bank has posted us a query that this is flouting the new regime rules. So we asked them as to how it is flouting. So they said that we are yet to get clarity on this. As for us, this is flouting, so which is very strange. They said it is only so as in they were telling us about the law, like the regulation 19, only that the restriction in relation to the double layer structuring is not applicable only for banks or NBFCs or insurance companies and government companies. So since you are only a family offices, this won't sail through. You have to go for an approval only. So without RBI approval, they won't allow the transaction. So pursuant to which we posted it to them to seek a clarity as to whether this will be allowed or not, because they said that this may lead to round tripping, as this is clearly money is going abroad. And so we give them a clarity that this money is only being invested and we'll be holding less than 1% of that particular entity's shareholding. And being less than 1%, how will it even affect anything in the entire structure? And if you are saying that the money is coming back, so they were just questioning that this may lead to round tripping. So it's one of the renowned family offices. So they said that we don't care about that. It is flouting regulation 19. So we'll not allow this. So they have put this immediately to the officer in the relevant as in jurisdiction, and our transaction is stuck. So we have already started facing huge operational issues for the family offices, because earlier, see, so when these directions came, it was very welcoming that this will be allowed. But for, say, in terms of an MNC, which already has more than 2 layer of subsidiaries and wants to come into India, so it should be liberalized a bit more in order to them to invest here and create such a robust structure that it is for the benefit of India, and every family offices or an Indian investor or say employees sitting here or some management people, those who are investing in these overseas companies or overseas startups. So they should be allowed, so that India is getting the relevant benefit, because that money in all the transactions which us as in our regulator might think or is getting experience from other jurisdictions is not leading to round tripping. So this needs to be, I guess, thought upon and clarified further, whether it applies for India or overseas. It should not apply to overseas. Otherwise, it is again a deal breaker, and it will go to RBI approvals, because in most of the cases there will be, uh, you know, issues pertaining to more than 2 layers. Otherwise, no one will be able to operate, because in all the structures, everyone has these entities being stepped down subsidiaries more than 2. for their, say, tax efficiency purposes or better holding or fundraise related aspects. So that's my view on this.
Looks like RBI is going to get a lot of clarifications to be sought for round tripping.
Already in August, when these were issued for around 20 days, most of the AD banks were specifically instructed to stop all the ODIs. Like for example, if you see the definition of startups, it has been given as to how the startups will play through. So in most of the jurisdictions, there's no concept like startups.
Right.
So when a family office invests declaring that it is a startup, so they say that other jurisdiction doesn't recognize it as a startup. It is a normal entity for them. So this has led to more confusion because AD Bank is pretty neutral because they simply say that we don't want to be reprimanded or lambasted by RBI at any point in time.
Okay. So now that all Indian entities are allowed to invest in entities engaged in the financial services sector, what sort of opportunity does it present for businesses in India? Sumit, would you like to share your viewpoint on this?
Yeah. So, like earlier, Indian entities were not allowed in financial services activity, which is now permitted to invest in financial services activities, subject to the fact that profitable. There are conditions like profitability of 3 years requirement is there, which is a pretty welcome move because there are already entities which want to foray into. So this is a very positive move, since it enables Indian entities to either enter into the international financial services market and explore new type of opportunities which are either remotely or directly related to their already going business regime. So, and under the old regime, prior to making investments in the financial services sector, all Indian entities were supposed to or required to get registered with the regulator, which was actually a deal breaker. And if you see, under the new regime, our government has made it clear that it want to promote IFSC as a key jurisdiction among other things, wherein now Indian entities are involved in FSA as an financial services activity can invest in IFSC through the ODI route without any net profit requirements, and the scope of OPI has also been extended in IFSC by allowing Indian entities to contribute in investment funds as well. So, in addition to this, what has been seen that government has allowed resident individuals also to make ODI investments in foreign entities engaged in financial services activity as well. So, and further, there's another concept which has been come up with, deemed approval, which has been introduced like earlier, like what I have seen, government wants to actually show that we are not a lethargic government or bureaucratic, in a manner that if they have come up with the deemed approval concept, that if a regulator doesn't approve the application within 45 days, the requisite approval for the particular financial services regulator concerned shall actually be decided within 45 days and shall be deemed approved. As in, if they fail to reply or they fail to raise any query in relation to that. So, which is actually pretty welcoming move. So, this will permit and benefit family offices or the Indian entities which want to invest in fintech entities and who want to try as to how this will play in the financial services sector without getting their registrations with the relevant regulators in India. This is indeed a very welcoming move.
Right. The new OI regime has introduced the concept of pricing guidelines, which requires pricing to be done on an arm's length basis. So, Abhik, what are the implications of the new pricing guidelines under the new regime?
So this is well, actually, it's a entirely a new requirement that's been introduced, because under the earlier regime, at least, there was no such there were no pricing guidelines that were applicable for overseas investments. There were certain circumstances in which a valuation was required to be done, like if there was going to be a transfer of shares or a share swap. or a acquisition in a foreign entity, then there was a requirement for evaluation to be done, but there was no stipulation that about whether the transaction had to be done below or above whatever the valuation that was determined. So now this is something new that's come in, which is sort of, if you see the drafting, it's quite familiar to what is set out in the NDI rules for investment into India, where essentially the valuation should be done as per an internationally accepted valuation methodology. But as far as the pricing guideline itself goes, whatever the fair value that is determined, that is essentially the price at which the overseas investment should take place. So I think that's something that where the government has decided to be a bit more prescriptive, I would say, and create a requirement where there wasn't one earlier. But overall, it probably logically it makes sense, and it sort of ties in with the existing FDI regime as well, in terms of how valuation is a requirement there. But there again, there's no stipulation, at least under the overseas investment rules, about who the valuation needs to be carried out by. So I think there again, that's something where clearly it seems like the intention is to give some flexibility to parties. I think one of the questions that we had gotten initially when these rules came out was, is it that just like under the NDI rules, does the valuation need to be done by a SEBI-registered merchant banker or a chartered accountant in India? Or does it have to be a registered valuer under the Companies Act? Now, the rule is completely silent on that. And, I think while again, this might be something where some more practice may evolve, but, I was just, when I was going through the rules, I did notice that where the intention is there, the rules have been prescriptive. So, one of there is now in the provision that deals with writing off of losses in an overseas investment, where essentially the value of the investment has reduced. Then that diminution in value in certain circumstances needs to be certified by a valuer, and there the stipulation is very clearly given that it needs to be a registered valuer under the Companies Act. Now, the fact that the rule that talks about pricing guidelines for overseas investments does not have any such stipulation, I think to me that that certainly seems to indicate that there's more flexibility there as to whether it's a valuer, even whether it's a valuer in India or you get a valuation done abroad. It does seem to be sort of leaving that open for parties to decide, as per whatever suits them the best for their transaction.
Right. Thank you, Abik. ODI in startups has been expressly distinguished from other international investment avenues. Few nations work with clear definitions of a startup. So the phrase loses its meaning in countries that do not recognize startups. Do we need more clarity on this under the new regime? Pallavi, would you like to share your views on this?
I think, Sandhya, in the last half an hour that we've been having these deliberations, the common theme seems to be that, yes, there is a lot of work that has been done, but at the same time, there is a lot of clarity that still, I think, is required. So, Sumit was talking about this earlier, that, yes, startups have been sort of segregated from the rest of the ODI regulations, and it has been said that for startups, if you are investing in a startup, then it must be a startup within the definition of the host jurisdiction, and the investment can be made only from internal accruals and not through loans. But if we just step back a little bit and see where the government's impetus is, or what is the thought behind it, I think that largely investment in startups, and if you see the league table of startups, you know that we were in the top 10 or the top 5. So the startups really are in US, UK, Australia, and Canada, UK as well. So the top 5 countries where startups are the maximum, or the registered startups are the maximum, are these 4 or 5 countries which have a fairly well-established startup definition, and have a fairly well-established startup culture, definition, rules, etc. So if you're looking at investing in any of these jurisdictions in a startup, then you're sort of in clear domain. But if you're looking at countries which don't have a clear definition of startup, then obviously it's gray. And for them, it's a normal company. I mean, we were not very far away from this situation before Modi ji's vision of startups, and 2015 DPIIT came into the picture. So we are only at 22. So we are only sort of 7 years away from when we got our definition of startups, and all of this work has been done in that startup space. So now that we are also capital exporters, and we want to invest in startups, in technology, in infrastructure, in pharma, where a lot of work is being done in this space. I think there is some definition there in a lot of countries, and I think there is still a need for those countries also to look at startups like we have looked at in our country, and Startup India and Stand Up India, was our slogan. So maybe other countries will also follow suit, because innovation is happening really in the startup space. So I think, yes, there is clarity needed. And yes, there is a lot of work that has already been done.
Yeah. Abhi, would you like to add something to it?
Yeah, sure. Thanks, Sandhya. And as Pallavi said, I think clearly there's on this point currently as it stands. Honestly, it feels like a bit of a dead letter, because if other jurisdictions don't sort of have a legal definition for startup the way that we have here in India, then really it'll be up to the authorized dealer to sort of take a call. And I don't think that that's something that most authorized dealers would really be open to without getting some guidance from the RBI or the government. So clearly, I think sort of this the requirement that startup for the purposes of these rules must be an entity that's a foreign entity that's recognized as a startup in its home jurisdiction. That'll be a bit tricky right now. I think one sort of point of discussion with the banks has already been that whether we can extrapolate the Indian definition to foreign jurisdictions, where because in India a startup is essentially a company or an LLP that's less than 10 years old, has turnover below that I think 100 crore limit, and it's engaged in an activity that it's a scalable business model, or it involves innovation, etc. So if arguably, I would think that until we have a situation where for other popular jurisdictions we know what a startup, how to identify a startup in those jurisdictions. If until then, perhaps one way to address it is to sort of at least try and satisfy the authorized dealer that, look, if this entity were incorporated in India, then it would be eligible to be registered as a startup because it fulfills those requirements. And so therefore, you should be able to treat the overseas investment into that entity as as investment into a startup. Because I think the other, one, obviously there is a stipulation that essentially if you're investing into a startup, you can't be borrowing funds. You have to use own funds to make that investment. But there's also, it's quite interesting that in the, there's also this concept of strategic sector in the rules, where definition of strategic sector is, energy and natural gases sector, but it also refers to startups. And the sort of the relaxation for investments in the strategic sector is that it does not have to be in an incorporated entity, and it doesn't have to be in a limited liability entity. So what really isn't clear is whether when you look at startups as part of the strategic sector, is it only startups who are engaged in energy and national resources sector, or is it that any startup essentially should be treated as being a strategic sector entity? I would be inclined to the latter, simply because just reading that definition, the word startup doesn't really have anything to do with any of the specific sectors that are mentioned there. So it seems to be a separate category. But clearly that's a relaxation that's been offered to Indian corporates that might be looking to do overseas investments. So, it would be sort of it would be a bit surprising if the intention were to liberalize it on in one aspect, but to also sort of hamstring it in another by just leaving the definition of startup very vague.
Right. Thank you. The long-standing confusion between portfolio investment and ODI has been cleared up now. And the investor universe has been expanded to include unlisted Indian companies, mutual funds, etc. How significant are these changes? And how are they likely to impact the investment landscape? Would you like to share your perspective, Pallavi?
Sure, Sandhya, thank you. So I think in the old regulations, first only listed Indian entities were allowed to make these investments. Now, when they've changed that definition to include Indian entity, an Indian entity is defined under the Act to say a company defined under the Companies Act, that includes even unlisted entities. So suddenly, this restructuring that Abhi, Sumit, and Kalpit were referring to before me, where only listed entities were permitted. Now, even unlisted entities, through this mechanism, are allowed to invest in overseas entities. So I think this is also a big game changer, which allows this investment to happen in these overseas entities. So first, if you saw the definition, it said portfolio investment by listed Indian companies. And this limit of 50% was there. Now, with this new regime, it only talks about investment by Indian entity. And the IE is defined to mean, it means Indian entity. And this Indian entity is defined in Companies Act. Sorry, Abhik, I think your speaker is, mic is still on. Sorry. So now that unlisted Indian entities are also allowed to invest up to 50% of their net worth, it allows even unlisted entities to invest in overseas structures, right? So this has really opened up the world, so as to speak, for Indian unlisted entities. So I think it's a great move. It is opened up the whole universe for them. So I think it's great. And even for mutual funds, even under mutual fund regimes, AIFs, VCFs, mutual funds, all of them are now permitted to invest in the overseas entities and overseas mutual funds. So it has really, I think, opened it up for all of them. The mutual fund definition used to be as per the Income Tax Act. Now it is said that mutual funds that are SEBI regulated. So I think the clarity and the openness that has come through these new regulations is a welcome measure.
Thank you, Pallavi. In the past, Indian entities were permitted to lend to companies in which they had an equity interest. However, the new regime allows Indian firms to only lend to their direct subsidiaries. Sumit, what's the upshot here?
Yeah, so what has been done is under the regulation 4, so an Indian entity may lend or invest in any debt instrument issued by a foreign entity subject to certain conditions that such loans are duly backed by loan agreements, and it is again put on the AD to check whether the interest rate is being charged on arm's length basis or not, whether as to these are done after the documentation of necessary agreements between those two entities or whoever is involved for any other related aspects of such agreements or not, as to they need to assess the bona fides of the transaction. So that has been assessed, and it has been categorically stated that an Indian entity is not permitted to lend directly to its say overseas step down subsidiaries. So, but what they have done is that they may lend to companies in which they have direct interest, which Kalpit and Avik have covered. But again, these interests should be charged on arm's length basis, and there should not be any conflict of interest. And they have also, prohibited resident individuals to make financial commitments by way of debt in these foreign entities also. So this is a very balanced move, I must say. But again, it will require some more clarity by the AD banks, and because this is operational requirements for the overseas subsidiaries. So it will be seen as to how, as in, and what documentations will be given and sought by the AD banks in allowing these transactions further. So again, this is yet to be tested, I guess.
Right. Absolutely. So according to this new regime, only instruments that are compulsorily convertible or irredeemable qualify as equity capital. So the redeemable and optionally convertible instruments would be regarded as debt now. How will this impact Indian entities going forward? Abhi, would you like to share some light on this?
Sure. Thanks, Sandhya. So I think at the outset, the good thing is that there's a clear grandfathering provision in the overseas investment rules that essentially, if there's an existing structure, as long as it was compliant with the previous regime under FEMA 120, then it'll continue to be treated so as under the current rules. So it will be interesting to see how exactly AD banks would consider this in light of optionally convertible instruments. But presumably those would essentially be treated, whether as equity or as debt, depending on how depending on the intention of the Indian party. I think going forward, though, one, obviously, even if these optionally convertible instruments are treated as debt, given that comes under the larger umbrella of financial commitment, obviously it doesn't really change anything as far as the overall ability of an Indian entity to subscribe to these instruments, because it's subject to that overall cap of 400% of the net worth. I think the one thing that will obviously that will change now is that being treated as debt, it obviously then needs to comply with the regulations on this point, including that under the new overseas investment regulations, the debt can only be given by an Indian entity to its direct subsidiary, obviously, but it needs to have acquired control in that in the entity that's receiving the debt. So and I think maybe this is one of those places where there might have been some thinking about the reduction in the percentage from what we usually see as amounting to control, which would be either more than 50% or more than 25%. For the OI rules, it's just 10%, and possibly that is to make it easier for Indian entities to actually provide debt or subscribe to debt instruments of their subsidiaries or on behalf of their subsidiaries.
Okay. So, Ms.
Sorry,
yeah, please.
I just want to add here that this also brings parity with the tax laws. So in tax laws, we didn't have this mezzanine financing, which was different. So the pricing guidelines under the FEMA laws was treating this as equity and not as debt. Whereas in our tax laws, the same thing had to be valued and was treated as debt. So there was always a disconnect, and clients were asking for two valuations, one under the debt regime under the Income Tax Act, a second under the equity pricing mechanism under the pricing guideline. So there was a contradiction in the two laws. I think this has also brought this in parity with the tax laws and has removed that contradiction.
Yeah.
Right. Sumit, would you like to add?
Yeah, I was about to say that only that, now actually, I guess government is actually seeking the right, as an advice of right professionals while framing all these regulations and aligning it with the already existing laws, so that there is no contradiction or issues with like Companies Act or Takeover Code in a manner like, like this Regulation 3 only, that they have specifically given that the entity should be, eligible to make ODI. It is already made ODI in a foreign entity, and has acquired control. So why it is doing all this? We need to understand the background in a manner that it wants that particular Indian entity to be secured in a manner that it is making investment in redeemable, say, or OCPS type of instruments after compliance with these three conditions, so that you already have control before you are investing in debt instruments rather than equity. So they actually want so that tomorrow when there is a issue or any litigation, you have all your hands secured and your investment is already ring fenced through your equity participations and backed by the shareholders agreement, which are made compulsory while doing ODI now through AD banks, because they are going through various scrutiny levels. So this is indeed done in a manner that straight debt is not possible without complying with these three conditions, and they have acquired control also aligned with. Hence, this will make it more stricter also, and they'll be able to check all these debt related transactions in a much better manner, so that all these will be already covered in your FLA and your other reportings being yearly reporting. So it will be much more easier for the bank to track these also.
Right.
Yeah.
The new rules appear to be country agnostic in the absence of restrictions on the location of the overseas investee company. So, Sumit, what sort of risk will the new regime have to grapple with in terms of tax evasion or money laundering?
Yeah. So see, earlier, RBI had no specific, what can I say, as in specific definitions, as in still they have not put in the regulations, but earlier they have only had a FAQ 64, which was, restricting these aspects pertaining to step down subsidiary structure in if you invest from India as an ODI-FDI structure. But now, if you see the drafting of the regulation, so this has been made in such a robust manner that they have aligned it with the Companies Act also, tax laws also, and reportings have made so detailed that if you actually try to, do a way around or find loopholes somewhere or the other, just like your tax returns as in TIS and AIS have been come up with. So you have to be very sure as to what you are doing, and they are very worried of the fact that our forex reserves are also depleting, money is going outside of India. So in order to curb all these practices and money laundering, so they have come up with various checks and balances, like for example, for in case of a disinvestment, this is a very important clause. You will not be allowed to disinvest from a particular entity in any manner whatever if your UIN is less than 1 year old. So this is a very balanced check from someone who is either from the enforcement has proposed this, that if your UIN is less than 1 year old, it is an automatic approval. And that limits that if it is above, say, 10 million, again, you have to go for an approval from the Reserve Bank while going for disinvestment. So this is a very balanced approach, and they are trying to curb it as much as possible. And I guess this is a very right approach by aligning it with various laws. If you see that they've specifically named companies law restrictions for layerings in the regulations and rules. So which actually gives it a fact that they have aligned all these aspects in a manner so that they're actually put in place checks and balances, and there is less and less conflicts and confusions and gray areas. Still there are and gray areas which only be pertaining to, I guess, only the procedural requirements, which AD Bank and RBI will be clarifying as per our interactions with the AD Bank and RBI of late.
Right. Thank you so much for sharing your perspectives on these new OI rules and regulations. Thank you so much. We will now take up questions from our audiences, and we have one question. It says, Can an India company provide corporate guarantee or non-fund based support to its WOS abroad to raise debt from an FI, which can further be pumped into an Indian company? Will this be allowed under the revised guidelines?
Let me see the question.
Should I repeat? Or would anyone would like to share their perspective on this question, the answer?
See, the thing, so I'll just share what our interaction has been of late. So, see, financial institution, yes, it is possible indeed, but it is again will depending on your AD bank as to how this will be allowed, because what kind of financial institution it is. So that will require clarity. The transaction is appear to be is indeed possible, but it will require operational related clarity from your AD bank. So this can indeed be done. There is no problem in the transaction.
Okay, thank you. We have our next question from Sanya. She says, please clarify if the layering will be construed vertically or horizontally in an organizational structure. I think we have spoken a lot about layering of companies.
it is yet to be clarified. I guess RBI will be coming up with an FAQ on this.
Yes, yes. What will be likely impact on inward remittance to India?
Inward remittance, I guess he means by with respect to the ODI-FDI structure, that will only depend on the clarity as to how many layers are allowed.
Right. Then we have our next question. It says, if NRI individuals want to carry business of export of sugar, will it be covered under automatic route or approval route? They will incorporate a private company in India. This is very much specific to a particular transaction.
Yeah. I guess I will say that he can reach out to us and that we'll answer.
Yes. So we would like to, want more, information on this transaction to be able to give you the right answer, right?
Exactly.
Right. Thank you so much. I have one query, if I may ask.
Yeah.
So, should we expect a detailed FAQs from the RBI on these rules and regulations and directions?
For sure it will happen. Yeah.
Within a span of like 2, 3, 4 months, because the companies have already started working on these, they have started their transactions based on these OI rules and regulations, which has a lot of lacunas and loopholes.
Yeah, for sure. It has to, as in they have to come up with some detailed FAQs in order to help everyone decipher the gray areas which are still there.
Right.
Yeah.
Thank you so much. Thank you, Pallavi, Abhik, Sumit, and Kalpit for your valuable time in sharing your viewpoints, standpoints, and perspectives on these OI rules and regulations. Thank you so much. And thanks to all the participants for being with us till the end. Thank you so much.
Thank you for having us. I think this was a wonderful deliberation.
Yeah.
Thank you
very much.
Thank you, everyone.
So much.
Thank
We
you
will now end the session.
Yeah.
Thank you.